Good afternoon, Mr. Chair and members of the committee. My name is Terrence Wilson. I'm the Regional Policy and Community Engagement Director for the Intercultural Development Research Association. We're an independent, nonpartisan education nonprofit committed to achieving equal educational opportunity for every child through strong public schools that prepares students for access to succeed in college. We are opposed to this bill because of the threat that it poses to the access and use of curricula that affirms the identities of all students, particularly students that identify as part of the LGBTQ community. While the bill drafter's goal of protecting students is laudable, the provisions contained within this bill may in actuality do the opposite. In fact, in operation, this bill threatens students' access to materials that may eventually be covered and protected by the First Amendment of the U.S. Constitution. While the bill's language appears to incorporate the Miller Standard, as the chairman mentioned before, this is a high bar, and we feel that placing the responsibility for interpretation of this high bar, not with judges or other trained legal professionals, but rather with local school principals or designees that aren't specifically trained to make these determinations, is a problematic approach to these bills. As the chairman mentioned, it takes an opportunity for lawyers and other folks to be able to set the standards listed here. We think that it's foreseeable based on this process that a lot of the information that would be prohibited might actually be information that is going to be allowable under First Amendment protections. We ask that the committee remember the words of the Supreme Court written in Aronofsky versus Jacksonville back in 1975, which says that, quote, minors are entitled to a significant measure of First Amendment protection, and only in a relatively narrow and well-defined circumstance may government bar public dissemination of protected materials to them. The court went on to state that speech that is neither obscene as to use nor subject to some other legitimate prescription cannot be suppressed. Solely protect the young folks from ideas or images that a legislative body thinks is unsuitable for them. Thus, we think that you all should consider rethinking the wisdom of creating this system that will likely lead to protected content being restricted. Furthermore, beyond legal considerations, we believe that this bill is likely redundant based on the current provisions outlined in the Georgia rules and regulations that are available for you all to review. As Representative Kendrick asked for, there are several rules that govern these kinds of issues, specifically Georgia Rule 160-4-4.01, which governs instructional media resources, Georgia Rule 160-4-4.2, which governs instructional materials advisory committees to be set up that include parents and other local folks in the community, and instructional material selection and recommendations found in Georgia Rule 160-4-4.10. These provisions value local control and include parents as an eligible part and important part of the process. Likewise, the current provisions value the expertise of our educators and our media specialists and our librarians who are trained to choose appropriate materials for young people to access. Finally, we are concerned that under the current processes proposed in this bill, materials that cover topics from minority perspectives and that explain and address themes including racial and ethnic minorities, LGBTQ plus individuals, and religious minorities may be removed or censored. We've seen this happen in other places that have enacted similar provisions to the ones in this bill. For the aforementioned reasons, we ask that this bill be withdrawn and instead legislators enact measures to bolster community-based approaches to ensuring that curricula and instructional materials affirm all students' identities. Thank you.
I believe next we have Noel. Oh, pardon me, Mr. Wilson, if you come back real quick. Chairman Setzler.
Mr. Wilson, thanks for being with us today.
Yes, sir.
Wanted to ask you, I'm fond of quoting President Obama, who said an appeal to first principles is useful. It really gets right down to the heart of issues, and I appreciate his perspective on that. I would echo that. Let me get right to the heart of the issue. We talk about some folks have some details to work out in the language, and it's very important we get the details right. But in principle, do you believe that members of the public, taxpayers, adults, should be able to have access to see all content that minors in our public schools have access to?
In principle, I believe that parents should be a huge part of the process, and I believe that our current regime that we have in our rules and regulations cover that involvement and that ability to see those materials.
So I'm going to ask you an uncomfortable question because I want to go right to the point. And you partially answered my question, but you did answer it.
Okay.
Be very specific. Do you believe parents
Mhm.
ought to have access to every single piece of content that's made available to their minor school kids?
Yeah, I believe that parents should absolutely be able to understand what students are learning in their schools.
Broadly learning, but specific on a content by content basis.
Right.
Every single image, every single word of text. Should parents, if they ask and go through the process, should they be able to see every single thing that students have access to in the schools?
Yeah, it is my belief that parents currently have the ability to be a part of not only what their students experience, their own individual students, but also a part of the process where we determine what students can learn. So I believe that they already have that ability.
Part of the process. But so you believe today, well, it's debatable whether they have it today, but it's a first principle question.
Mhm.
Do you believe that every parent ought to have access to see any piece of content that's available to kids, even if they may not appreciate the content, or even if they're not the ultimate deciders on whether it should be there? Should any parent be able to see everything that their kids can see?
Yes, I believe that's already the case.
So you believe it should be, you believe that parents should be able to then?
Yes, and I believe that they have the ability to do that under the current rules. The problem that I have with the bill is not in parents having the ability to see what their children are learning. It's actually the part in the bill that would prohibit and censor what students can learn based on these rules that are hard to interpret and that don't have the same processes where lots of different perspectives are included. So if me as a parent, I wouldn't want what I determine to take away an opportunity for another child in the school. So that's why we have a collaborative process as it stands.
Okay. I'm not sure we're reading the same bill. I'm reading LC 413138S, and in 413138S, in nowhere are
Mhm.
parents taking away content. Only educators,
Mhm.
principals, and then people ultimately under the school board, the school board itself at the district level,
Mhm.
are making those determinations under the bill we're debating. So there's no issue about suppressing that. This is simply an issue, if you're reading this version of the bill, is that anything that kids can see, parents and the public have access to see themselves. There's nothing that can be said. That can be, hey,
there is
kids
a
can
large-
see this, but mom and dad can't really know that it's being
Right.
seen.
That is one part of the bill. There is another part of the bill, right, that would allow a principal, as you mentioned, or a designee to say that this bill is harmful to minors and for that content to be suppressed or to be censored. So that is a part of the bill that concerns me.
Well, if you're a principal though, and I were a parent, for example, and I came to you and said, hey, there's this content here that I think is objectionable. You looked at it and you thought, and I wouldn't hold you accountable as a principal that every single book on the shelf of your school, you've read every word of. So I would expect, hey, Mr. Wilson, I've got this, take a look at this. And you looked at it and he's like, oh my gosh, this is not consistent with the values of the DeKalb County schools or Cobb County schools. Thank you, Mr. Setzler. We think this is, good catch. This is not appropriate. Maybe it was appropriate sometime in the distant past, but it ain't appropriate today. So it's gone. Wouldn't you thank me for that?
Yeah, I would like for it to be a systematic process. Even if I were a parent, I would want every other parent that's like me to be able to have that same right. And so I think that we don't want it to be a case by case basis in terms of having different standards for different materials. I think that what we want to have is a comprehensive, systematic approach, which is what is reflected in the current regulations.
Yes, systematic, and that every parent have that same right. And that's exactly what this bill does, that every parent in Georgia has that same right. Some districts might accommodate this today quite well, but every district does not. We know that. And we believe, as you said, every parent should have the same right to a systematic approach. And we talked about 180 different school districts. I mean, it's Representative, one of my colleagues said before, it's different every place. Why do we need a common process? Well, this isn't being decided. I know you referred earlier, the legislative body believes it's obscene. We're not making those decisions. What we're doing is, to your words, setting up a systematic process that every parent has a right to follow to make this happen.
And then to ban the materials is the part.
No, but the school leaders are making those decisions, not the parents, but the school leaders. The school leaders make the decision in every single circumstance. And to the point you agreed that every parent, adults should have access to what the kids can see. That's exactly what this bill does, Mr. Chairman.
I think we may have a different understanding of what exactly the bill does, but thank you, Mr. Chairman, for your questions.
Go ahead. We've got another question over here. Representative Bodie.
Yeah. First of all, thank you so much for being here. And we appreciate you presenting to this body. Now, you said something that caught my ear earlier about principles. And will you not agree that right now, even some of our Metro County boards of education have had hyper political meetings where it has been disruption? Now, with this legislation, that political pressure would now be on one person. Is that not true? The principal.
That is correct.
And then the principal will have to deal with the fallout, not at a school board meeting, public school board meeting, but within their office and at their school themselves.
That is correct.
Thank you so much, sir.
Any further questions?
Chairman Burchett.
Thank you so much, Mr. Chairman.
Chairman Burchett does have a question, Mr. Wilson.
Mr. Wilson.
Yes, sir.
Thank you very much for your testimony. Just tagging along what Representative Bodie and Chairman Setzler said, you pointed out the current statutes 160-4-4. And if I could read from an excerpt from there, what it allows is development of procedures for the school system and for selecting material locally, handling requests for reconsideration of material. Would you agree that this is the same thing that we're doing here? Handling requests for reconsideration of material, but we're putting deadlines on those requests?
It is my assertion, yes, that we are trying to do the same things that already exist in the regulations. Yes, sir.
Thank you, sir. And at this point, the way the statutes stand right now, though there is no provision within law that takes away that decision from, we don't know who makes the decision now, do we?
And which decision? Can you be a little bit more
The decision
specific?
for what is obscene and what requests are, what materials are requested to reconsider.
I believe that in that regulation, there's a list of folks that are mentioned that should be included, I believe.
So what I'm seeing here is that they are to develop procedures and school systems. So what we're doing here is essentially in line exactly what you referred to. We're just outlining deadlines for this thing to be, for these materials to be seen about, whether they're obscene or not. We're not changing anything substantively of who's making this decision. We're saying that the Board of Education locally must make that determination in a reasonable amount of time versus just, letting it sit on someone's desk.
No, I understand. And I think that, the opportunity may be there to work within the regulation, but it is our contention that this bill is not necessary and it may be redundant for, as you mentioned, because some of the rules are already there. So if the committee has a desire to protect students, which I think is laudable and we want to applaud you all for, maybe it's an opportunity to go into that legislation, work with folks, as we mentioned, from the Department of Education, other community groups to do this instead of doing it here at the legislature.
Well, very good. I appreciate you again for coming out here and
Yes, sir.
giving testimony. Thank you.
Thank you. Any other questions?
We do have one Representative
popular debate.
Montahan.
Thank you, Ms. Wilson, for coming in and giving your testimony. I do have a
Yes,
couple
sir.
of questions. You had spoke about the narrow kind of lens that we're looking through for the First Amendment rights of the children. And I'm trying to find out where that's going to fit. And so you as a professional, what kind of books do you think should be censored?
I think honestly, it's going to be a case by case basis. It's going to be based on what the student's level of development is. I think the problem that I would have is here, from my perspective here, trying to predict what kinds of materials are going to be considered obscene under this rule.
Further question then, let's say in your profession, I know you had a pretty good statement on this. So let's say for an eighth grader, what would you say you shouldn't expose an eighth grader to?
I'm an attorney. I don't feel comfortable speaking on what eighth graders should and should not learn. I think that we can have a process that's informed by child development, educators, all the different folks that are listed. So I unfortunately cannot speak to what's appropriate for an eighth grader.
Well, I am not an attorney, so I understand. what would you tell somebody who says that maybe the procedure isn't working? You talked about many procedures that are currently in code. You said, these procedures are working. But I'm looking at, again, this is accessible to an eighth grader. It says torture porn in the wake of 9/11, horror, exploitation, and cinema of sensation, or secrets of porn star sex, brilliant ideas for no holds barred pleasure. And again, even the chapter titles, I'm just trying to understand if, as a professional, you believe that fits within the narrow lens that should be censored.
I think that we should leave those determinations to the folks who are closest to school children. I think if I had an eighth grader, I think having things in EBSCO hosts might be a different determination as to what's actually being utilized in the school. That would be a question for your librarians and for your educators. I think also we just have to be aware of the fact that our students have access to all kinds of things via their cell phones. And so being able to determine what they should and shouldn't see, I think that it would be hard for me to sit here and say what an eighth grader should or shouldn't have access to. But those would be my considerations. I would leave that determination into the hands of the folks who are closest to education that can make those decisions. Our educators, our librarians, our library media specialists, folks who could work together to do that.
I mean, just one more, Mr. Chairman, if you will. I just want to kind of back up Lance. Again, I'm not a lawyer. I'm with Kansas State University. I know some places folks went to some bigger schools and some more knowledgeable places. From what I understand, I thought it was a pretty good school. But just from an outside
Agreed.
lens, I mean, right off the rip, just off the cuff, I'm just looking at this issue from maybe a 30,000 foot view. We probably shouldn't have, an eighth grader looking at torture porn. Just throwing that out there. So I guess my question is right off the rip, that is, you would say, hey, look, we really need to dive deep into this issue and find out if an eighth grader needs to look at torture porn. I'm just asking the question.
I don't know if, what the students should be learning. It depends on what their educators feel is, they're responsible and their maturity level. I would say that I think that the problem comes in subjectivity, right? So you may have a closer, we may agree on something like torture porn, for example. We may or may not agree, but they're in practicality, but I think there are things that will be in the middle. And for us to have a process that we can work together to understand what some of those community standards would be, because subjectively leaving it up to the principal, I think is problematic because they may have a different view than I may have as a parent. And it can go both ways, So I think that's the problem that we should really be considering is who we can be bringing into this process, right? To be involved with these decisions on the front end. So I'm sorry I couldn't answer your question directly, but that's kind of how I believe.
No further questions.